Have you been wondering what exactly does the separation and divorce process in Ontario involve? In other words, what happens during the separation and divorce process in Ontario? Hi, my name is Thomas O'Malley. I'm an experienced family lawyer in Durham Region and the GTA. The first thing you want to do is to make sure you get the advice of an experienced family lawyer before taking any action whatsoever. You need to have a plan in place before you take any action at all. You have two main approaches to follow to deal with your separation or divorce. You can try to negotiate a separation agreement with your former spouse. This usually is a good idea since it is less expensive and takes less time than going to family court. The key is that your spouse has to cooperate to negotiate a separation agreement. They have to act reasonably, in other words. Your lawyer will send a letter or email to your spouse in which they state they believe you and your spouse can reach a friendly or amicable resolution of your family law issues with a negotiated separation agreement. Then your spouse will usually hire a family lawyer to represent them in negotiating a separation agreement. You and your spouse need to exchange full financial statements and provide proof of the value of your assets and the amounts of your each debt set out in your financial statement. Then your lawyer will prepare a draft separation agreement for you to review and approve. Usually, you and your lawyer will make some changes to this agreement until you're both satisfied with it. Your lawyer now sends the draft separation agreement to your former spouse or their lawyer. Your spouse will usually request some changes to the separation agreement. This back and forth in negotiating a separation agreement is very common, so don't worry about that. When both spouses are relatively reasonable, you can reach a settlement with your negotiated separation agreement. This process usually takes a few months. If your spouse is unreasonable, you might have to take your former spouse to family court. This means that your family lawyer will draft specific family law documents for your review. When you approve these court documents, they are served on your spouse. Your spouse then has 30 days to respond to your court paperwork with their own court paperwork. Then you have several scheduled court dates called conferences. These include a case conference and a settlement conference. A judge will make specific recommendations on how to settle your case at these conferences. This is very important. Most cases settle based on some version of a judge's recommendations. Fortunately, most cases do not go to trial, which is the end of the family court process. The family court process usually takes from 1 year to 18 months or longer to complete. If you have any questions about your separation, divorce, or family law case, and you'd like our help, feel free to contact me on my Facebook Law Office page, that's O'Malley Family Law, or call me at 905-434-8837, and I'll point you in the right direction. Please make sure to share this important information and video with your friends, family members, and coworkers.